So how long will it take a workers' compensation judge to approve a settlement that's been sent in for approval? The best answer I can give is it depends. It could be as fast as the same day the settlement could be approved. Unfortunately, also, it could be longer. See, what happens if a settlement is e-filed by the insurance company or by a defense firm and you don't have an attorney, that will go into the board for processing. It will get assigned to a judge. The judge has, by rule, 15 days to act on that settlement. So generally, judges try to work on settlements relatively quickly. They know that everybody is interested in getting the settlement approved, but there is a lot of work to do, so it may take up to 15 days. The judge then has to determine if the settlement is adequate. So if the judge finds adequacy, if everything was filed properly, all the correct documents, medical reporting, a printout of benefits, everything was filed correct, the settlement was adequate, and you as an injured worker with no attorney, the judge is still confident that the settlement is adequate and that your rights have been protected, the judge will issue the order approving or the award approving the stipulations, and that will generally go to the judge's secretary. That then gets served on anyone on the official address record, or in these days of COVID, it may get emailed to the defense firm or to the adjuster, and that person will be designated to serve everyone else. So how long does it take? It's possible the settlement could get approved the same day that it's filed. It's possible that it may take up to 15 days to get approved. And it's also possible, unfortunately, from your perspective, because you want the settlement approved, if the judge cannot find the settlement to be adequate, what will happen is the judge will issue an order suspending action. We have another video covering that topic. That order suspending action will issue, it goes out to the parties, and the case will get set for a status conference. The parties, in the meantime, can either fix whatever was wrong, whatever the judge noted in the order suspending action, or you can discuss it with the judge once it gets set for a status conference. So the downside there, the settlement gets filed, it may take a couple of weeks before that order suspending issues, and then it may take a month or two before you get to the board and have a hearing in front of a judge. At the time of this filming, we're still doing conferences by telephone or occasionally by life-size cloud over video, but it'll take a couple of weeks potentially for the order suspending, and it may take up to a couple of months to get to the board, talk to the judge, and address whatever problem was found. You may be able to, at that point, explain the issue to the judge, fix whatever it was, allay the judge's concerns, and the judge may approve the settlement, or the judge may need further information. The judge may want a panel qualified medical exam. The judge may find, let's say, that the primary treating physician report that you're settling on simply isn't adequate. It's not substantial evidence, and you need to go to a QME. The judge may find that there's not enough of a medical basis, so you simply need to return to your treating physician. By the alternative, the judge may need additional documentation from the claims adjuster. Let's say if there's some issue of a temporary disability overpayment or something along those lines. So it's difficult to say. The only bottom line that I can offer is that a settlement may be approved as quickly as the same day. It may take a few months. The judge may disallow the settlement entirely and order the parties to work on a new settlement, let's say after you go to a QME, after additional discovery takes place. So there's really a number of variables. And I hate to say it, but the bottom line really is, it depends.